Hello, welcome. Happy Thursday. So excited. Last week was an awesome Thursday. This week is an even better Thursday. Things are smooth, fixing things. Yesterday turned out the reason why there was a reverb in my play was because the music, for some reason, my other computer decided to play something random. So you were hearing things that you maybe shouldn't have been hearing. Not bad, but just stuff that wasn't supposed to be on the mic. And so, yeah, that was what happened yesterday. Gotta love tech issues when you're trying to do everything. And I'm sitting here trying to figure it out. And I guess now would be a great time to go ahead and mute the other computer. There we go. That way, if something else comes up, that won't happen. So today we're going to be talking about contracts that work. Now we're going to be talking about some legal clauses, which are just things that go into the contract that will help you get exactly what you want out of the relationship. Because if you don't, those types of things can hurt you later down when you need them. Now we're going to talk about why you need a contract, because I deal with lots of people that are like, that's okay. I don't need them. My word is my bond. You're correct, except for there are certain instances when you have to have a contract, a physical written contract. And also, there are also things that you can hurt you by not having them in there. So you really want to take a deep look at yourself and go, is this what I want to do? And it's always better to get it in writing. One of my law professors used to say, if it goes without saying, it usually goes better with. And nothing could be more accurate than a contract, a written contract. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. I'm happy to have you here. We go live Monday through Friday, except for holidays, at 11 a.m. So tune in to get your legal questions answered. If I can answer it, I'm happy to help. If I can't, I have a vast resource or vast network of attorneys that I can reach out to and see if we can get you some help from one of them. Also, keep in mind, I am located in California, so all my legal advice or legal question and answers are based on California law, not based upon Arizona, New York, whatever, if you're joining me from a different state. So keep that type of thing in mind, that these types of things are California, and as they say, your mileage may vary. So let's get started. Awesome. Welcome back. So, number one, a contract defines the relationship. And there are certain instances in which case you have to have a contract. For instance, if it's a contract for services that are beyond a year, so if the experience is going to take them beyond a year, it needs to be something in writing. It has to be. Because otherwise there's what's called the statute of frauds. And the short version of it is real property always has to be in writing, and as well as any type of service contract that if it's beyond a year, if the performance date is going to be beyond a year. And then also if it's goods for more than $500, then it has to be in writing as well. So there are certain instances where if you don't have a contract, you don't have nothing. And that's very important to keep in mind, that sometimes, your word is your bond, but by law, you're required to have them in those specific instances. There's a few other instances that things are required to be in writing, but those are very rare, so I'm not going to touch those. So one of the benefits that contracts are worth and can really help you is the selection of venue and choice of laws. Whenever you're dealing with anything that could be misconstrued or construed incorrectly, having it in writing and having it so that it benefits both parties. For instance, that if you're going to sue somebody, that it's going to be that it's going to have to be in a certain place and you're going to be subject to certain laws. That changes what you may or may not do. Now, if you're the drafter of the contract, you can specify what it is that you are trying to do. So in other words, if you want to restrict it to only being able to be sued or in the local area so that it's convenient for you, you can actually put that in your contract. So keep that in mind, that contracts are meant to define the relationship but give you avenues for recourse in case things go bad, which is the strongest reason why you need to have a contract. Because yeah, your word might be your bond, but that's a whole lot of trust in the other party that their word is their bond. So going with writing and having it in a real form will give you a better option than if you just stick to your word. It's not that you think that the other party isn't, but how well do you know the other party? So next is alternative dispute resolution. So alternative dispute resolution is short for, or a fancy way of saying, mediation and arbitration. And those two things keep you out of litigation. And those are ways to resolve disputes quickly, efficiently, that you can get a resolution that doesn't cost an arm and a leg. Litigation is by far more expensive, but it takes substantially longer. And with the court systems the way that it is, that you could be waiting years for something to be resolved. In fact, I've got a case right now that is, let's see, we started it in January, right before the pandemic hit, January 2020. Yep, January of 2020. And it might see the inside of a courtroom by the 2023, to give you context, to give you an idea of what you're looking at. So arbitration and mediation can give you a shorter time frame, but there's no right to that. Okay, so that's why having a contract that says that alternative dispute resolution is to be used is important, or vital even, not even like questionable that you should have that. So in other words, in your contract, you can dictate that it must go to mediation first, then arbitration. And if you can't reach a resolution, that then you can go to litigation. So those are all things that you need to consider. Now, in some instances, I've recommended that it be only litigation because it incentivizes the parties to settle faster rather than drawing things out in the litigation thing. So that's another thing that makes contracts work for you. I've had cases where we've had to go to arbitration. We did arbitration, and it worked out great for my client. So you're going to get a different result depending on arbitration compared to litigation. Mediation is simple in case you're unfamiliar with mediation. Mediation is just a single person that goes between both parties to see if we can get to a resolution. So you'll still have an attorney on both sides, but the problem with mediation is typically it's not binding. So if you don't reach by choice an agreement, then you have to go to arbitration or litigation, depending on where you're already at with it. So that's something that you need to know about having this in your contract, because there's no default that says that you have a right to those things. Okay. The next thing, and these are these clauses that I love putting in contracts, especially for my business owners. You can limit the amount of damages, okay, to a reasonable amount, which also disincentivizes people to sue unnecessarily, because then they're not going to get absurd amounts of damages. So, for instance, if you perform a work and there's $1,000 worth of damage because you didn't show up, and I'm just using that as a for instance, I'm not saying you would, or 4,000 or 10,000 or whatever number that it is that you didn't perform on, if you have a limited damages clause, then the max that they can sue you for is this, as opposed to the damages that they have. So 1,500, 2,000, as opposed to if your damages are 15, 30,000, then that could bump things up, which affects whether or not you'll settle or whether or not you'll proceed with the lawsuit, right? Because if your damages are limited to only the amount that you've spent as opposed to any type of punitives or beyond that damages, it's a fancy word for punish, punitive, then you're going to reduce the likeliness of being sued. And all you would have to do is refund them the money. So some instances we can put that in, other instances we can't. There are certain standards and guidelines per each industry. So, that's why it's important that you consult an attorney in your local area, because if you're not doing that, or if it's illegal for you to do that, you definitely don't want to do it. The next thing is indemnity clauses. This is another thing. If there is something that happens that's outside your control but is within the control of the other party, then you can have an indemnity clause that requires them to fund everything if there's something that goes wrong, which is a really great clause because you never know what's going to happen with third parties, right? So those are the things that you've got to think about in regards to contracts. And I'll give you for instance. I dealt with a wedding photographer a while ago who thought that their contract that was a single page, very limited, would protect them better because they couldn't be held to something. The problem is there are rules and laws not against that, but there's what's called the parole evidence rule that says if something's not within the four corners of the contract, and I'm oversimplifying here, that it doesn't exist. You had a chance to negotiate on something, and so it also is that the law is typically construed against the drafter. So if there's an issue with your contract, then you're risking a lot by making it too broad, too vague, not clear enough, not defined enough. And so by having that contract in place, it could have reduced his damages, but instead it hurt him more. There's what's called a waiver clause. And I love waiver clauses because if, for instance, you waive something in the contract verbally or with a writing, then you can say that just because I waive it for this doesn't mean I'm waiving it for that, which is a great way to make sure that the contract stays intact and that people can't get out of it. There's also what's called a severability clause, which means if it's found something's in violation of the law, that one clause might be invalid, but the rest of the contract would be valid. So these are all just certain things that, sorry, it's like when you talk and you have a nose that vibrates, it just makes it so that it's hard to concentrate. Anyway, so if you are trying to run a business, the last thing you want to do is have to deal with these types of issues, right? You don't want to have to go to court. You don't want to have to go to mediation, but it's better to have these things in place for when it goes wrong than to not have it at all. Because if you don't have a contract at all, then it's just your word against their word. And it runs into a lot of issues because it becomes a he said, she said issue where you are he said or he said, she said, whatever. It becomes their word against your word. And then it makes a big difference in your potential outcome. That wedding photographer that I mentioned, we could have gotten damages at about $2,000 if the contract would have been written correctly. But instead, they got $6,000. Not because of anything I could do, but because the contract was so vague and so incomplete that my hands were tied by the laws that are outside of the contract, which is the other thing that you have to consider. There are default rules in society for a reason, okay? There are laws that exist. If you want to contract around those things, then you have to put it in writing, and both parties have to sign it. So these are the things why contracts work. Contracts are beautiful. Contracts are some of my favorite things to do because of the beauty of defining that relationship, creating a understanding between the parties that's clear and that isn't up for interpretation other than you do the work or perform the job or provide the service, not the service, the product, whatever it may be, and the other party get paid, right? So it's clear the relationship is clear, I found that it's much better to go into that relationship with clear expectations than it is to risk that people might not be completely forthcoming in their dealings, right? And so contracts, again, like a lot of people, oh, my word is my bond. Great. Handshake deals, great, but get it in writing, right? The next part of it is define it, get it in writing so that you're protected. If you've gotten value out of this video, don't forget to hit subscribe and like, and remember that I go live Monday through Friday at 11 a.m. to help you answer legal questions. I'm happy to be here. If you have any questions on the replay, feel free to leave them in the comments below. I'm happy to answer them so that you can get the help that you need. Remember, it is California. There are some general questions that I can answer, but if there's something specific to the state that you live, then I will refer you to counsel there. So until next time, we'll see you later. Have a good one. I'm trying something new today, so I'm hoping it'll work in about 30 seconds.